All right, let's just try to finish at least up to easements. Easements, para tira natin for Thursday yung modes of acquiring ownership, tapos donations. Okay? Ito natin. Let's see how far we can reach before we get to all enjoy the holiday tomorrow. Okay. Wala kayong review bukas? Wala naman. Okay. Try to, when reviewing for the bar, hindi pwedeng puro aral at puro basa. Okay? You should find time to relax. Ha? You need relaxation just as much as you need to study. Okay? Because you'll be able to study better if you are relaxed, relax kayo. Paminsan-minsan, pag lalong ganyan, halimbawa, mamaya, pagkatapos yung magsimba kayo, linggo ngayon. Kailangan nyo, more than any other time, you need to pray. Okay? Try to find time to relax a bit. Okay? Try to see a nice movie. There are 1,001 ways of relaxing. Okay? Kailangan yan. Hindi pwedeng puro aral. Makukurtong utak nyo yan. Pag puro aral. Alright. Pag-usapan naman natin yung use of rack. Okay. Wala namang komplikado. Nothing complicated about use of racks. Okay? The basic idea of use of rack is property is given to a person, is given the right to use and enjoy the property with the basic obligation of preserving its form and substance. Basically, that's what use of rack is all about. Okay? Now, you try to remember at least a few of the distinctions between use of rack and lease. Kung minsan tinatanong yan, you need not remember all of the distinctions. You just remember some of the distinctions. Okay? For example, one possible distinction is that use of rack is always a real right. In the case of lease, it's not always a real right. It becomes a real right only if the period is more than 1 year or if it is registered. Okay? Mga ganon. A use of rack can only be created by a person who owns the property. Siya lang ang pwede mag-constitute ng use of rack. Yung lease pwede. It will be created by somebody who is not actually the owner of the property. For example, the lessee may actually sublease the property. Okay? In the matter of its creation, there are various ways of creating a use of rack. It may be created by the law itself. It may be created by the will of a testator. Okay? In the case of a lease, generally the only possible source of lease is the contract between the parties. Except, of course, in the case of the implied new lease. Okay? Or in the case of the forced lease under Article 448, if the value of the land is considerably more than the value of the building, the landowner cannot compel or ask the builder to buy. They may just enter into what is sometimes referred to as a forced lease. Yung mga ganyan. Tandaan lang natin yan. Okay. You remember the rights of a usufructuary. Okay? So, if you are the usufructuary, what will be your rights? Basically, you can use the property. You're entitled to all of the fruits, whether natural, industrial, or civil fruits. supposing there are hidden treasure there, insofar as hidden treasure is concerned, the usufructuary, the law says, is considered a stranger. In other words, if somebody finds the hidden treasure, then the usufructuary does not get any share of it. If it is the usufructuary himself who finds the hidden treasure, then he may be entitled to one half of the hidden treasure, and the other half will go to the naked owner of the property. Okay. You remember the provisions of the law regarding growing or pending fruits. Okay. Those fruits which are growing or pending at the commencement of the usufruct will belong to the usufructuary. Those growing or pending fruits at the time of the end or termination of the usufruct will of course belong to the naked owner. With respect to the fruits pending at the time of the start of the usufruct, sabi natin, they would belong to the usufructuary. Does he have to refund to the naked owner the expenses incurred? So far, there is no need to refund the expenses. But when it comes to the fruits pending at the time of termination of the usufruct, while the law says that they will belong to the naked owner, the naked owner has to reimburse the usufructuary the expenses incurred by the latter for cultivation, seeds, and other similar expenses. Okay. If the property under usufruct is tenantable, pwedeng i-lease or i-rent out to tenants, it is the usufructuary, not the naked owner, who has the right to determine who will be the tenant of the property. If there are any accessions, halimbawa, the property under usufruct happens to be a parcel of land, it's located along the banks of a river, and in the course of time, the area increased because of alluvion, the usufructuary has the right to make use of the additional area. That's part of his right under Article 571. The usufructuary may decide to personally use the thing, personally enjoy it, or he may allow another person to enjoy the thing under usufruct. Okay? But remember that all contracts entered into by the usufructuary with third persons are coterminous. Coterminous with the usufruct, with the exception of lease of rural lands, which shall be deemed to continue up to the end of the agricultural year. The obvious purpose there is to allow the lessee who may be cultivating the land to continue with the production and gathering. Okay. Usufruct imposes upon the usufructuary the obligation of preserving the form and substance of the thing. Okay? But the law allows the grant of a usufruct over the entire patrimony of a person. And when that happens, chances are in that patrimony there will be some properties which by their very nature will deteriorate or will be impaired due to ordinary wear and tear. All right. Supposing that what has been given by way of usufruct is property which gradually deteriorate through ordinary use, ordinary wear and tear. Halimbawa, a car. Siyempre, yung kotse. If the usufruct is for 5 years, after 5 years, iba na yung kotse yan. Ordinary use of the car will result in ordinary wear and tear. Can the usufructuary use the property? The answer is yes. Pwede pa rin. What will be his obligation? He is simply obligated to return the thing in the condition in which it may be at the time of termination of the usufruct. Of course, if the thing suffered damage or injury due to his fraud or negligence, he is obligated to indemnify. Pero kung ordinary wear and tear lang, no obligation. Okay? He simply has to return the thing in the condition in which it may be found at the termination of the usufruct. Okay. Can there be a usufruct on consumable things? Consumable things, those which cannot be used in a manner appropriate to their nature without their being consumed or used up. Okay? Can there be a usufruct on money? Can there be a usufruct on rice, for example? The answer is yes. Okay? But, well, these are what are sometimes called abnormal usufructs on consumables. Sometimes called quasi-usufructs. But I think the better view is, well, as pointed out by some commentators, if the object of a usufruct is consumable, in effect, what you have is a simple loan. Simple loan yan. Okay? So what will be the obligation of the usufructuary? Siyempre, he uses, he consumes, then he simply has the right to return or pay their appraised value at the time of termination of the usufruct, if they were appraised. Now, if they were not appraised, he will have the obligation of returning the same quantity and quality or pay their current value. That's one advantage of having an appraisal. At least you only have to return the appraised value if they were appraised. With respect to usufructs on fruit-bearing trees, remember, the usufructuary cannot cut down the trees, but he is allowed to use the trees which have been uprooted by accident. Okay, yung mga dead trunks, he can use them, but if he does, he has the obligation to replace. Okay, he has the obligation to replace them with new plants. Fruit-bearing trees, halimbawa, mga fruit-bearing trees, santol, okay, or mangga, okay, or kaimito, star apple, yan. If there is something extraordinary which happens, okay, and the trees have been uprooted or disappeared in such extraordinary number that it would be impossible or too burdensome to replace them, the usufructuary may simply demand from the naked owner to clear the land so that he can continue using the land, or if he wants, he can use them, but if he does, he will have the obligation to replace them with new trees, pursuant to Article 575. Okay. Usufruct over woodland. The usufructuary is allowed to make such ordinary felling and cutting as the owner was in the habit of doing, or in accordance with the customs of the place.